to the next page. I don't see anything that seems to suggest that it addresses the requirement of section 64B. But of interest is there at the middle of paragraph F, where it says, thus, when providing me with this address on the 14th of April 2023, applicant knew she was no longer staying at this address as the contract expired in January 2023 and had unceremoniously vacated the property on 21 March 2023. Here, Your Worship, on their own version, the state is saying, notwithstanding that the fact that a lease agreement had expired, but applicant was still staying at that particular dwelling. So the fact that whether or not there was lease agreement, according to them, she was still staying there. So what is the effect of a lease agreement? Does it mean because if a lease agreement has expired, therefore that person is no longer staying there? It's not the case. According to them, lease agreement expired, but she was still staying there. That cannot therefore be used as a ground to say that she's a flight risk. 64B is about flight risk. All that is written here is intended to prove that she is a flight risk. And therefore it can never be said that she was misleading, because out of their own version was still staying there. Lease agreement expired, but was still staying there. And Your Worship, there is this issue of obtaining affidavits from the Health Professional Council on the 14th of April 2023, and the whole issue of applicant failing to pay the prescribed fees at the Health Professional Council. What does it have to do with a flight risk? Because remember, this is an evidence that the state is saying, on the strength of it, you are a flight risk. It has got nothing to do with that. And unlike the case of the applicant, where the applicant deposed to an affidavit, and in relation to hearsay, despite the fact that hearsay is also admissible in bail proceedings, she went further to obtain confirmatory affidavits. Where are the confirmatory affidavits from the state? Nothing. Captain Colonel Flyman is saying, I obtained an affidavit from Health Professional Council, but it's not even affixed or attached to the affidavit to substantiate the veracity of his allegations. Nothing. There's an allegation that therefore at the time of her arrest she was no longer permitted by law to practice as a medical doctor. What does it have to do with the flight risk? At the bottom of that paragraph, of that page, I established that the medical center is registered with a different address at Townsend Road, Bedford View, Johannesburg. What is the status of a business? Isn't it that a business is also a juristic person in terms of the law? It is written here, Optimum Medical Holdings Group Pty Limited. The law of company law is very clear on that. A company is a juristic person capable in terms of the law of making transactions, acting independently from its directors, and there was nothing wrong with that. In fact, applicant was complying with the law when she registered her company and making use of an address for that particular company, because she was not that company, but the company was a juristic person. Now the state is making an issue about that. And if you turn to the next page, Your Worship, there is paragraph H. It lists about 6 companies. All of them are alleged to be companies of the applicant. They are even saying to some of them, she has resigned as a director. But despite that, they are putting that information on an affidavit. What is it intended to prove? Is intended to show that there are so many addresses, different addresses for each and every company. If you are residing in Bloemfontein, are you not allowed to have a company in Durban and have that company registered or have a registered address in Durban? That is what must be the case. Which is the case, and which was the case even here. And for record, Your Worship, can I take instructions on this? Some of these companies were already dormant. The state considered this to be essential to put it on record in order to persuade the court to say, this is an applicant with various addresses, therefore she's a flight risk because there are so many addresses. It is not the case, I submit. And that this evidence is not relevant for the purpose of this exercise. If you look at paragraph, why do you use that word? Is it a professional one to be used under these circumstances? I will request the court to have a look at the dictionary meaning of the word. And I submit that it is inappropriate to could have used this word in the context of this sentence. The issue of self-calls being made to legal teams and friends and all, I submit it has got nothing to do with the flight risk. And for that matter, it is incorrect to say that applicant is not keeping in touch with her children. It's a lie. The next page, Your Worship, if you look at allegations that are made that applicant first accused 5 from KwaZulu-Natal after the escape using this same Porsche, a tracker confirmed the movement. If a tracker confirms the movement of the car, does the tracker confirm who was the driver? What kind of submission or argument is that? I submit that this can never be argued to say it supports the requirement of section 60 subsection 4b. It can never be. the applicant left this Porsche with her security when she fled the country. What evidence do they have that she fled? We placed evidence before this court regarding how the applicant left. The matter was adjourned for more than 2 hours for the state to consider its case. Did they ever rebut that version as to how she left the country? No. Do they have any proof of what they are alleging here of fleeing the country? No. Nowhere in this affidavit you'll ever find that. Paragraph K, it is true that applicant had a passport and it was taken by the police. And we submit that on that basis, she cannot be a flight risk. The issue of the passport being used 23 times for trips outside South Africa. The passport is in possession of the police. Ordinarily should have been at least attached to show proof to that effect. That has not been done. But if you also look at what they are saying, they say he went out of the country 23 times, but he was still coming back to South Africa. What happened to that 11 months they allege in the affidavit? If that was the truth, despite that she was still coming back to South Africa. Now why do you say she will escape, she will not stand trial? We deny that she was in possession of 2 passports. We deny, and we stated that categorically clear in our papers. But the state says he was in possession of 2 passports. Where is evidence to that effect? And remember, Your Worship, the arrest happened in Tanzania. Where was Captain Colonel Flyman? How does he know about that? If he was relying on evidence from the foreign authority in Tanzania, where is proof to that effect? Nothing. He does not even, as a matter of courtesy, mention a name that according to so and so from somewhere or in Tanzania, this was the situation. He speaks as if he has got personal knowledge of this, and this is not the truth. The unfortunate part of it is that I cannot cross-examine Colonel Flyman on what he's saying, but I submit that this can never be the truth. Joseph, paragraph L. The applicant has everything to lose by remaining in the country, and there follows number of cases. There are further criminal cases. Okay, there are further criminal cases were registered against her. This include, then the state went on to mention 6 cases. As if not enough, they even decorate those cases with huge amounts of money. First one amount involved 15 million plus minus. It's not the exact amount, plus minus 15 million. The second one fraud 500,000. Third one fraud 1.2 million. Fourth one fraud 5.112 million, and so on and so forth. But what's also important, if you look at the case numbers of these matters, you'll find a case number of April 2023, of February 2023, March 2023. Where were these cases? We are sitting now in tomorrow is the last day of August. Where are these cases? Applicant has never been approached by a single police officer in respect of what is alleged here. Not a single. But let's also look into the law to say, can this actually be, if it is true, be a reason advanced by the state to say applicant has got anything to lose by remaining here because of these cases that are written here. And if you take it further and read the next paragraph, paragraph M, it says the applicant is not only facing long terms of imprisonment if she is convicted on the above mentioned matters, but is also facing further civil claims. The applicant has not been charged, has not been arrested, has not been approached by the police, has not been brought to court. In fact, these cases cannot be regarded as pending cases against the applicant. There's none. There's none. And I'm saying this, I'm seeking reliance on the provisions of Section 60, subsection 11, capital B in bracket, which provides that in bail proceedings, the accused or his or her legal advisor is compelled to inform the court whether, Roman Euro number 1, the accused has previously been convicted of any offense. Number 2, there are any charges pending against him or her, and whether he or she has been released on bail in respect of those pending charges. This relates to pending charges. Conditions thereof is that the legal rep or the accused must say, in respect of those pending charges, what is her status? Is she released on bail? Is she in custody? Is she... So with regard to this, they don't even if they can be squeezed to fit in this provision. They cannot fit in. I submit that in terms of the law, these are not pending cases. I'm pushed to come to this submission because of what Colonel Flyman states on paragraph number M, to say that if she is convicted on these cases, as if she is the accused on this matter. She's not an accused. Then I want to move to page a page which has got paragraph 8.3. I don't know what page number is that, but it has got paragraph 8.3, and 8.3 deals with section 60 subsection 4C. Section C, your worship, states that where there is likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. This is what C is all about. But if one looks at the state evidence in relation to C, it's only 2 lines. And I submit that those 2 lines, they don't come anywhere nearer to what is required by 4C. And what is written here is that some of the witnesses are known to the applicant. The counts of corruption are an indication that she could influence witnesses. It is all that Colonel Flyman can say about the state case in relation to the requirement of section 60 subsection 4C. That is all that which he can say. If we move further and look at section 60 subsection 4D on the very same page, there are only 2 points that are made there as evidence of the state upon which they are addressing the requirements of section 60 subsection 4D. And this, Your Worship, it relates to the likelihood that the applicant, if released on bail, will undermine or jeopardize the criminal justice system, including the bail system. And they are saying, A, the applicant, knowing that the information is false, brought a false application for the release of the body. 1. 2, they are saying, the applicant, knowing that it is false alleged in the High Court of Bloemfontein that she was kidnapped from Tanzania. That is all that they could say under section 60 subsection 4D. Nothing else. They don't say anything. These are the only 2 aspects that they are saying. But now if you look at B, it really does not make sense. The applicant, knowing that it is false alleged in the High Court of Bloemfontein that she was kidnapped from Tanzania, I cannot make head or tail out of that sentence. But this sentence, it is intended to address the requirement of section 60 subsection 4D. I don't know how it is going to address it. If you look at A, it makes reference to, does it talk to D? That state alleges it was brought. Next is section 64E, that there is exceptional circumstances that the public peace or security, a likelihood that the release of applicant will disturb the public order or undermine. And here now the state is saying, the nature of these offenses induced a sense of shock to the community. It was a well-planned operation. Doesn't state by who. At E, these crimes jeopardize the public confidence in the criminal justice system. The persons who were to ensure that a dangerous person, Bester, was locked up, was put back on the street because of corruption. And then it goes on to say corruption is a huge problem in the country. And basically that was all that they could say. Then they moved to look at the evidence of the applicant. I have a problem with what is contained at paragraph 10.1. where Colonel Flyman says he scrutinized the supplementary statement of one Natsai Michelle Chibaya. Where he says he's a Zimbabwean citizen. What is wrong with that? A medical doctor. She's a medical doctor. Coming from our neighboring country, Zimbabwe. What is wrong with that? Who obtained a permanent residence in the Republic of South Africa in July 2018. Nothing wrong with that. It's in terms of the law. But they went further to say her residential address on the system of Department of Home Affairs is whatever address in Johannesburg. Notwithstanding the fact that he was aware that he has now obtained a permanent residence in South Africa, he still wants to create something negative about the doctor. What is the purpose? She's not in the country illegally. She complied with the law. She's supposed to be in this country. She has got permanent residence. Why refer to address at Home Affairs when she has got her own address? And she's a doctor, an African doctor, but she's referred here that the fact that this person has been staying in this address only from January 2022 is concerning. This person, she's an African doctor. Is it despising her because she comes from Zimbabwe? I don't know. But I feel I have to raise this because it's inappropriate. He knows. He read our affidavit that she's a doctor, but he says this person to a doctor. It's inappropriate and not respectful. Sounds very xenophobic. And I'm saying this because if you read the other sentence, this is evident that applicant has close ties with Zimbabwe. Her friendship with this person, she states she will stay with, is concerning. I don't know if it is an appropriate way of putting it here. But if I read this affidavit, I am convinced that Colonel Flyman is not a person who is not learned, because in his affidavit, he made reference to State versus Diwani. He's a learned person. But when it comes to the doctor from Zimbabwe, this person. This must not only be viewed in light of what I'm saying, but it must also be viewed in light of the interest of the applicant before this court. Because it is the applicant now who wants to be admitted to bail, who has got a friend from an African country who says she's referred to as this person. It cannot be right. And under paragraph 10.2, paragraph 7.4, the state is saying, is alleging that applicant was suspended from practice as medical doctor in December 2021, and if she had been practicing as she alleged, this was unlawful. As stated in our papers, Your Worship, applicant had a business. and owing to an expectation contained under paragraph 7.4, which talks of tertiary education and work, aesthetics, a skin care and aesthetic clinic in Sandton. And she informs me that what she was doing there, it had nothing to do with the normal practices of a person as carrying out work as a medical doctor. Because there she was doing her own kind of work, which falls outside the normal ambit of a medical doctor. I am actually reminded that the record will reflect that out of the co-accused of the applicant, all of them are released on bail except for 2, and there's never been any public disorder of whatever nature. And even today, it is still normal. Nothing is happening. At paragraph 10.3, I have addressed it why that aspect, because it's repeating itself, Your Worship. And other allegations contained there, I will also address them at an appropriate time during trial. And Your Worship will remember that in our papers we also states how applicant left the country, and I see that the state is making a counter allegations to say since the arrest no case was opened of kidnapping. Our submission is that it is an individual's choice and decision to decide on how you deal, on how you forgive, and on how you deal with your past. And actually is a matter that will be dealt with at a later stage. And Your Worship, then there is pictures which were attached to the application. If you look at the affidavit of Colonel Flyman, he is making reference to those pictures. The originality of those pictures, nobody is saying anything about. We don't know where they're coming from. We don't know where they were kept before. We don't know who interfered with them. He's not addressing any of those. The authenticity thereof, nothing whatsoever. But they are intended to prove what they are purported to mean. We submit, Your Worship, that the court should not put too much weight on that kind of evidence. The court knows principles governing the admissibility of evidence. And that brings me, Your Worship, to the end of the case for the applicant, for the state. And I was bound to address it in such a way due to what has been alluded to in the affidavit. But I must end by saying the nature of evidence upon which the state relies upon is of a very poor nature, is unsubstantiated, notwithstanding the fact that they make reference to so many people and the fact that they have even obtained their affidavits, but they never even attempted to file just one confirmatory affidavit, nothing whatsoever. But on the other hand, Your Worship, if you look at the affidavit of the applicant and the evidence of the applicant, it is simple and straightforward. She addressed the court about her own personal circumstances, honest with the traveling documents, the family background where she stays. She has got 2 children. Nothing was disputed in relation to her rights in terms of the Children's Act. In terms of the assets and the value of the assets, nothing was disputed. And what is the purpose in a bail proceedings of the court considering the assets held by the applicant? It is to ensure that there is value on what the applicant has, which will force her, whatever the circumstances may be, to remain and attend and not evade. But as shown and stipulated, it is clear, I submit, Your Worship, especially with regard to the submissions of the state, that she has been in and out of the country, going out and coming back, notwithstanding the fact that according to the state there was a period of 11 months, but she was still coming back, which actually we don't believe. The criminal history, she has got no pending cases, no previous convictions. And as I stated when I started my address, Your Worship, I have no reasons to believe that this is not a Schedule 1. And I have no reason not to believe that the state case is not as it was portrayed to be, especially taking into account all the factors which I showed through the charge sheet. as well as the supporting evidence. We gave our version, Your Worship, with regard to how the applicant left South Africa. It is contained in paragraph 8 in her affidavit. .1 up to 8.8. The question is, can we point out any evidence from the affidavit of Colonel Flyman which rebuts the version of the applicant? There's no such. Other than what the applicant is telling the court, the state has got no any other version to dispute what the applicant said on her affidavit. Her version remains unchallenged and there is nothing to the contrary. State has not shown that there is a witness or otherwise or any evidence of some kind to show that what the applicant is saying in relation to how she left the country is not true. It has never done that. Is that possible that I can ask just for 5 minutes adjournment? I just want to wrap up my address and thank you.
Yes. Now it's the time.
See here. It's another guy. 5 minutes.
Yes.